in the matter of the Financial Reporting Council Limited and Sports Direct International PLC.
May it please the Court. In this matter, I appear on behalf of Sports Direct International, the appellant, together with learned friend Mr Sher, and the respondent, the Financial Reporting Council, is represented by learned friend Mr Mark Simpson, QC, and Ms Rebecca Loveridge. As the Court knows, this is our appeal against the order of Lord Justice Arnold, dated the 11th of September 2018, for reasons set out in his judgment, which in turn followed a hearing which took place before him on the 24th and 25th of July of 2018. Before I turn to the substance of our submissions, my learned friend has a short matter to raise he's been good enough to notify me of. May that conveniently be done now?
My Lords, as you know, there's a confidential skeleton in this matter, and therefore I need to apply to lift the obligation to give that to the press. The obligation is under Practice Direction 52C. The application is not opposed, and on that basis I make it.
Yes, thank you.
I'm great.
Thank you very much. There are, as you know, 4 grounds of appeal in this case, which are at Core Bundle Tab 1, page 11. And as to grounds 1, 2 and 3,
Yes.
permission was given by the judge himself on the 11th of September at the hand down of the judgment. His reasons for giving permission are at Core Tab 8, and they amount to this, that as the infringement issue, he writes, permission granted since there are arguable points of law which merit consideration by the Court of Appeal. As to ground 4, permission was of course given by my Lord Justice Lewison on the 18th of December 2018, Core Tab 9, in these terms, whether the distinction drawn between a document and a communication of that document is a sound one is a question that ought to be considered by the full court in conjunction with the grounds for which the judge has given permission to appeal. My lords, my lady, the grounds divide, as you know, into 2 parts, for shorthand, infringement and communication. And each raises issues which go potentially to the very root of the law of privilege in England and Wales. The significance of this appeal is sharpened by the fact that the case arises out of an application by the Financial Reporting Council under a regime never before tested in court. As to each part of the appeal, we most respectfully submit that the learned judge fell into error in his analysis and in his conclusions, and this appeal should be allowed. May I just check that all the materials have reached the court before I get into the meat of the submissions? As regards bundles, there should be 1 core bundle, 1 supplemental bundle, and 1 confidential bundle. There should be 4 volumes of authorities, and then a small 5th file with 6 tabs of additional materials provided yesterday by the FRC.
Yes, we have those.
Thank you. May I just make this observation at the start? As to the confidential bundle, this is included at the request of the FRC, and subject, of course, always to the court's better view. We do not propose to make any reference at all to it in our submissions, whether anonymised and generically, or in such a form as requires sitting in private. As regards skeleton arguments, for the appellant there are 2. The first is a replacement appeal skeleton argument, which I'm sure the court has probably separated, but its original reference was in the core bundle, It is now dated the 22nd of January and replaces the one of the 12th of October.
Yes.
And a supplementary skeleton of the same date, 22nd of January. For the respondent, there is more. There is the original appeal skeleton argument, replicating core bundle tab 3. There's a supplemental appeal skeleton argument, replicating core 4. And then two skeletons dated the 22nd of January, the first of 2 pages, which is an update to paragraph 35 of their first skeleton argument, and the second of 6 pages, as to which my learned friend has just made his application and deals with confidential issues. Subject, of course, to your wish that we approach matters in a different order, our intention is, with your leave, to structure our submissions in this way. First, I will set out our arguments in brief summary. Secondly, I will
On both points?
Yes, on both points. Secondly, I will deal with the factual context. We believe this can be taken very shortly. Thirdly, I will introduce the court in such detail as you find helpful to the 3 regimes that are engaged in this case, namely SATCAR for short, the AEP for short, and the accountancy scheme, or AS for short. Fourthly, we shall deal with the infringement issues, taking grounds 1 and 3 together, or closely together anyway, because they really are 2 sides of the same coin, perhaps, and then ground 2. And then fifthly, deal with the communication issue.
Mr. Lizard, can I ask, is the only Rule 10 notice that we are concerned with that which appears in the supplementary bundle?
It is. May I try, therefore, to summarise or capture our submissions in 3 propositions?
I've got no objection to your doing it. Is the factual context going to be really of any great relevance here? Because in the sense that there's no dispute as to the factual context. The judge sets it out, and to some extent set out the skeleton arguments. I mean, that's not really going to bear on what are really issues of law here.
No, it's absolutely right.
I mean, why can't we take those as read? We've read that. We read these, give that background. We know what the factual context
I'm
is.
delighted to just put a line through that part of our speaking note.
Well, I mean, if there's something specific
Yes.
you really want to refer to either side in the course of the submissions, of course you must.
Yes.
But what we, on the assumption that which it would be correct, we have read the skeleton argument and we have read the judgment. In this particular case, I don't think the factual context makes any difference.
Quite understand. If that's the court's view, I shall leave it. I may just emphasise 1 or 2 points.
That's sort of on the assumption that we are being asked, as the judge was, to decide these points as matters of principle,
Yes.
rather than to decide whether any particular document or attachment is to be disclosed or not disclosed.
My lady, this court is at our joint invitation in the same position as the judge below. Principle, not detail. So may I just, in these 3 propositions, try to capture our case? Firstly, privilege is an absolute and fundamental substantive right on which the administration of justice as a whole rests. The right crystallises at the point of the client-lawyer communication and is subject to only 2 exceptions. 1, statutory override, whether it is express or it necessarily follows from the express provisions of the statute construed in their context, or 2, the fraud or iniquity exception. I don't overlook the fact that there is powerful authority to the effect that that isn't actually an exception, but I mention it because it's so treated in quite a lot of the cases. Save through one of these exceptions, any compelled production of a person's privileged material constitutes an infringement of that person's right, irrespective of the status of the compelling party or the later use to which that material is or may be put. And we respectfully submit that the judge erred in holding otherwise. Secondly, and alternatively, if one above is wrong, so if our first submission it doesn't find favour with the court, and if, as a matter of principle, the compelled production of a person's privileged material to a regulator solely for the purposes of a confidential investigation into a regulated entity, either A, does not infringe the person's privilege at all, or B, if it does, it is merely a technical infringement authorised by some statutory power. If all that is right, we respectfully submit that the judge erred in holding that principle applied in this case, given A, the real risk of the material being used in a manner adverse to the appellant, and or the express statutory preservation of privilege in the very regime under which the application for disclosure was made. And that's ground 2.
But isn't that really part of ground 1? Because you accept, your first proposition, you accept there can be a statutory override.
Yes.
Your second proposition was, the second part of it was that such a production is merely technical, authorised by the statutory power. Well,
Yes.
if it's authorised by the statutory power, there's a statutory override. So your point here is the judge misconstrued the statute. Isn't it the same point?
It's not with respect, I must say, the infelicity of my expression. In choosing the words authorised by some statutory power, I sought to differentiate between there being something which I will later perhaps call authorisation light, which allowed the court to nod through the infringement as we would have it, on the one hand, and on the other, there being either express provision in a statute, or it being, by necessary implication, as defined, for example, by Lord Hobhouse in Darby, meeting that high hurdle. As you will see from the authorities, and as I know my lords know this area incredibly well already, you know that there is a high bar set for statutory override, but what this case does is to introduce a different test of some looser term of statutory authorisation. So we do most respectfully submit that if consequential upon that holding there is such a principle, we submit it doesn't apply in this case, and that is our ground 2. So it is different to the first proposition. And the third proposition, which is the shortest of the lot, concerns the matter as to which my Lord Justice Lewison gave permission to appeal, which is this. We submit that for the purpose of determining privilege, a lawyer-client email and attachment is to be regarded as a single communication. Whether the document attached is itself privileged independently of the email is a separate question which does not inform, let alone determine, the privileged status of the communication. Now, those are the 3 founding propositions of our submissions in this appeal, and we will now seek to make all of those good.
With regard to the last, about
Yes.
the email and attachment being regarded as a single communication, it may be that by tomorrow you'll be in a position to make submissions in relation to the judgment that was handed down yesterday by this court, the Civil Aviation Authority and Jet 2
Yes.
judgment.
May I do that now, as it's in my lady's mind?
No, I don't want you to do it
Okay,
now.
well, may I give you
Yes.
a reference? In paragraph 106,
Yes.
pre-penultimate line, I think, says precisely that. So we shall come back to that in its proper context with your leave later, but we're grateful to you for reminding us of that, and we have considered it. Thank you very much indeed.
And just one other question while we're on these propositions. Your use of the adjective compelled withheld production
Yes.
is there designed to accommodate waiver of privilege, I assume?
Yes, exactly. It's anything that isn't premised on consent. Exactly. Passing over the facts, as I do, I invite you to the applicable regime. And I shall take this, I hope, sufficiently shortly for it not to be tedious. But may I start with SATCAR, which is Authorities Bundle 1, Tab 5. To give it just once its full title, it's the Statutory Auditors and Third Country Auditors Regulations 2016, and came into a force, as you know, from page 56, paragraph 1, on the 17th of June 2016. So far as the powers under which the regulations are made is concerned, nothing I think turns on this. You will have seen the way in which it is dealt with in Learned Friend's skeleton argument, and we have no submissions at the moment to make about it at all. You'll see the route through which into English law was imported European directive. And that is something which is a corner of this case with which we don't think this court need to be concerned. But may I take you, please, just very shortly to the relevant parts of the regulations. I've indicated already under paragraph 1.1 the date of it coming into force. Can I then come on in the interpretation section, which is section 2, page 57, bottom right-hand corner, and you'll see on page 58, competent authority means the Financial Reporting Council Limited, the respondents in the appeal. And then at the foot of the page, public interest entity means an issuer whose transferable securities are admitted to trading on a regulated market, and that includes the appellant in this case. And then on to page 61, please, and paragraph 3. You will see there set out under 3.1, the competent authority is responsible for, and then a whole host of things. And if I could take you conveniently to the bottom of the list, L, investigations of statutory auditors and audit work, and M, imposing and enforcing sanctions. Then if we come on to page 63, I merely invite you to note on the way through, if you kindly would, general requirements of auditors, so what is required of them is nothing more than one would expect. And then 5 is the competent authority's sanctioning powers, which are, again, a range, depending upon gravity. Then on to page 69, paragraph 9, monitoring of audits. 9.1, the competent authority must monitor the conduct of statutory audit work relating to public interest entities by means of a system of inspections that satisfy the requirements of Article 26 of the Audit Regulation. And then on to 10, please, on page 71, investigation powers, merely to note that they are set out in a schedule to which we will come and invite my lady to focus. And then page 81, Schedule 1 sets out requirements for professional ethics, independence, etc. I needn't trouble you with that. And then we come, finally, to Schedule 2 on page 82, which is the investigation powers under Regulation 10. I'll show you the corresponding provision in the audit enforcement procedure in a moment. May the court note, this page can correspond with authorities Bundle 4, tab 47, page 1114. That's the corresponding provision in the audit enforcement procedure. So, focusing on Schedule 2, Under subclause 1, the competent authority may, for any purpose related to inspecting or investigating statutory audit work, give notice to any statutory auditor, A, requiring the A to provide information specified in the notice. Then skip sub 2 and then come to sub 3. The competent authority may give notice to any person mentioned in subparagraph 4, requiring that person to provide information relating to the statutory audit of the annual accounts or the consolidated accounts of any public interest entity. And if one comes down to 4B, you'll see B is any public interest entity. And it's under this provision that the notice was issued by the FRC in April 2017 that is the genesis of this appeal.
And it's common ground that the requirement to provide information also includes a requirement to provide documents.
Yes, it is. And then if one comes down to sub 6, foot of page 82, a notice under subparagraph 1 or 3 may A, specifies the time and the manner, B, require the creation of documents or documents of a description specified in the notice, and C, require the provision of those documents to the competent authority. And then 8, a notice under subparagraph 1 or 3 does not require a person to provide any information or create any documents which the person would be entitled to refuse to provide or produce, A, in proceedings in the High Court on the grounds of legal professional privilege, or no corresponding provision for Scotland. Whilst we're in Schedule 2, could I invite you please on page 83, same page, down to paragraph 2.
Is there any particular significance in the reference to the High Court?
Now, I think it just means High Court proceedings, as we will see. This is standard language from many different sources, and my friend cites several in his skeleton argument.
Yes.
Paragraph 2 sets out the principles for applying to the court. I'm not going to dwell on the detail of it. And just for completeness, you can see that on page 84, under paragraph 3, and then over onto page 85 in 4, and over onto 86 in 5, provisions that deal with consequences of failure to provide, whether they be criminal or civil.
Yes.
So that's the SATCAR regime. May I take you now, more briefly, to the audit enforcement procedure.
And that includes the ability to come to the court, to apply to the court.
Exactly
to
so.
ensure compliance, which is what actually happened before.
Exactly, my lady,
Judge.
exactly. So in Authorities Bundle 4, tab 47, you will notice immediately on the first page behind this tab the date, 17th of June 2016. So it is concurrently introduced with SATCAR coming into force on the same date. And I merely invite you to note, if you kindly would, a very few provisions within this. The interpretation begins on page 1109 under paragraph 1. And on 1110, you'll see the FRC means the Financial Reporting Council. On the next page, public interest entity has the meaning set out in Regulation 2 of SATCAR 2016. And on the page after that, 1112, SATCAR has a meaning, the same abbreviation as everywhere else is used here. And statutory audit means an audit of annual financial statements or consolidated financial statements required by the Companies Act 2006 as amended. And then, and taking this in headline form only, if more detail is required, I'd be delighted to try to assist.
Well, what is the status of this document?
It is the procedure under which the FRC conduct its investigation into auditors.
Is it the force of law, or is it just their internal code of conduct, or
I
do you
don't-
sign up to it if you become an auditor? What is its status?
Yes, it is. The status is something perhaps my friend will want to explain better than me. But as you see from paragraph from part 2, it is, I think, a procedural document.
Which page?
Page 1113. That sets out, beginning with the initial stages, how internally they conduct investigations. I don't think it has the rule of law. I don't think it purports to be.
Is there anything in the regulation or statute which refers to the FRC producing a document such as this?
I was just about to say there is nothing, I think, that I know of. Melanophin is better placed than me, and I welcome correction. But my lord, no. So I was just going to say, it doesn't have the force of law in that it is not, as far as I know, made under any regulation. It is made under Financial Reporting Council Limited, a company limited by guarantee, own internal powers and duties.
It's guidance. Really.
It is.
Yes.
It sets out the many phases that there are in an investigation into alleged misconduct by an auditor,
Correct.
and when there's a hearing and when there isn't a hearing, and who's allowed to make submissions. But the power to call for documents is conferred by SATCAR, not by this.
Correct. There is a congruence of approach, as one would expect, between the two documents, but exactly as my lady says, the power derives from the regulation, which is why we started there, and why, as you pointed out earlier on, the application is under that provision. But this sits alongside it as being the procedure that is followed for exactly the effect that my lady just said.
Well, it's useful for showing what is likely to happen to any documents that are disclosed responsively to a notice.
Precisely.
So are you relying upon any part of this on your appeal?
On my...
Are you relying upon any particular part of this non-statutory document?
No, merely trying to illustrate the route that my lady has just identified. So you see the path, and I was only going to take you to 2 paragraphs, and I was done anyway, which are on page 1114, and it's 9 and 10. But they don't inform the legal debate at all. It is procedural. May I invite you to put that to one side, please? And then, just for completeness, we have added to your bundle, though I suspect it will be only of passing assistance, in the bundle that came yesterday, at tab 6.
This is which one?
The small black file that came yesterday. Yes. At tab 6. If this is an excess of information, it's entirely my own fault. I thought maybe it would be of use. I don't know. But so I'm going to deal with it extremely shortly. This is the parallel scheme, the accountancy scheme, that runs alongside the audit enforcement procedure. It is a voluntary scheme in the sense that various different governing bodies within the accountancy profession have signed up to a code that where an issue arises concerning a member or a member firm of one of those bodies, which appears to raise a matter of public importance, investigation and, if necessary, enforcement and sanction of that issue is given to the FRC rather than being done, for example, by one of the internal committees of one of the accountancy bodies. The reason why it's important is for a negative and a positive. The negative is this is nothing to do with SATCAR. SATCAR only entitles the obtaining of information for use under the audit enforcement procedure. This is common ground. And so it can't, material gain through that statutory route cannot, without some other permission, be used in connection with an investigation under the accountancy scheme. That's the negative. And the positive...
Is that common ground?
Yes. Without permission.
Permission from whom?
Well, there's, the permission is, within the order in this very case, there is a, in the recital at the beginning of the order, there is a provision that says that they won't use, the FRC won't apply to use the fruits of any order made in this case under SATCAR without first giving 28 days notice to the appellant and a person called Subject B, who you will have seen referenced in some of the detail, to object. And so permission to use, we would submit, has to come from the court, because the court will have sanctioned the obtaining of the material in the first place under SATCAR.
Can I try this?
If the FRC is entitled to require disclosure of the material, it is so entitled either because the material is not privileged in one way or another,
Yes.
or there's a statutory override. Well, what is the court doing, giving permission to override privilege if the statutory override applies only to SATCAR? How does the court...
We submit it shouldn't.
And if the material is not privileged anyway, then...
None of this
the court has to
arises.
do with it.
Yeah, no, we submit it, the court shouldn't, but it's only got something to do with it in the context that if the FRC obtain the materials under the SATCAR route, it is linked to and entitled to be used only in connection with the AEP investigation. If they want to go further, we say they can't. But if they want to go further, they have to come, it's agreed through an undertaking reflected in the order in this case, to the court.
Yes, but it's not only dealing with privileged material, is it? It's dealing with any material.
Yes.
They have to have a power to compel somebody to provide material of any kind.
Yes.
And that is the SATCAR power, and if they fail to comply, you can come to the court and get an order.
Yes.
Now, you're right in saying that the order that's obtained then prevents them from using any of that material for any other investigation.
Yes.
But I would have thought that a public interest entity should not be in a worse position if it voluntarily complies with the notice and doesn't dig in its heels and force the regulator to come to court. But so, would you say that even if there's no court order involved, because there is compliance with the notice, which FRC is satisfied with, nonetheless, non-privileged material that is handed over responsive to the notice still can only be used for the purpose of the SATCAR investigation and not for the investigation under any powers that other people have conveniently conferred on the FRC?
Yes, I do say that. I do. I think Malone was wanting, I think, to correct me. I'm very happy to yield, if that would be helpful to you, if I've made some mistake.
Lord, I'll come back to the statutory regime, if I may, in my submissions. There are some statutory gateways, and I'll return to
So
that.
I'm just trying to understand this. Thank you, the significance of the point you're making.
Yes.
And trying to place it in the context of the issues we have to decide. Where does that fit in to your analysis in relation to the legal issues? This point you're making about documents which are disclosed pursuant to SATCAR can't be used for this accountancy scheme without some sort of further authorisation. Where does that fit in?
I'm sorry, prejudice in shorthand, or exposure to risk, also shorthand. In other words, if the test, when we come to look at the authorities, if the test is one of interest versus infringement, in that if the use to which the materials are to be put is not one which exposes the public interest entity to adverse consequences, that, on one reading of some of the authorities, is okay. But we are going to be showing to the court that in this very case, one cannot have that comfort or confidence, in that it is quite clear that the FRC are reserving their position as to whether they can, in fact, subject permission of the court in this particular case, make use of the materials they have obtained under the flag of SATCAR, not only for the AEP investigation into the statutory auditor, but also under the accountancy scheme into Subject B. And Subject B was a senior employee of the appellants on the financial side, and he's being investigated for misconduct in the preparation of the very accounts which are the essence of the AEP investigation into the auditors.
And the investigation into Subject B is taking place under what?
The accountancy scheme, because he is by profession an accountant. He is therefore, by his governing body's agreement with the FRC, subject to their control, and that is the route through which they seek to proceed against him for misconduct. No, no, not at all, please.
So just so I can fully grasp this, so you're concerned that this material, if disclosed, may be used in this accountancy scheme
Yes.
as regards Subject B. As I understand, your submission is that it can't be, or shouldn't be, or that it may be?
No, that
legally? What is your submission?
all three, actually. It can't be, it shouldn't be, but it may be.
Because they don't agree that there is that limitation.
Correct. And this all comes under ground two, I should have said.
No, I know, but I just want to understand the
Yes.
the setting. Has the FRC been asked to give? The obvious way of doing this might be to give an undertaking, not to use it in that way. Have they been asked to give that undertaking?
Yeah, we have had quite an extensive exchange of our undertakings, and the first go was obviously wholly unacceptable. They had a second go. It is an issue at the moment that is parked, but I will take you, with your leave, when I come to ground two, and I think it'll be more helpful then than now, but I can do it now if you want.
No.
I will come to show you the correspondence on the point.
Okay, I understand.
But in this case, where in fact there is that qualification contained within the order, is it accepted that in this case they would have in fact to come back to court to be able to use the material?
Yes, they would.
And then there'd be a debate about the principles
There
upon
would.
which the court should either give or withhold its consent.
Yes,
There's
correct.
a whole raft of authority on that point.
Correct.
I see.
Whether my learned friend agrees with that, I don't know, but we'll find out.
No, but I just wanted to have the context, and you've given it to me. I'm grateful.
No, thank you very much, my lord. So may I now turn to deal with the guts of grounds of appeal 1 and 3, which I'm going to call the infringement issue. As to ground 1, we're going to make 3 points. We're going to, and I shall come back to the way in which I propose to do this in a moment, identify certain key principles concerning legal advice privilege established repeatedly at the very highest levels of authority. One of those authorities is, of course, Morgan Grenfell, and we will pick up the Morgan Grenfell dictum, as I shall call it for shorthand, and its two related aspects as part of that. Next, we intend to show you why the learned judge's no infringement reasoning is inconsistent with a number of core principles. In other words, it would represent a fundamental shift in the law's attitude to privilege, which is, with the greatest of respect, not something to be done in this court. Thirdly, I then propose to invite you to examine the case law which the judge relied upon and address questions of precedent in passing, although I suspect I shall leave that for now, and I see my lords.
You do quite a bit about
Yes, I think you know
what
quite a bit
binds
about
and
all
what
of this.
doesn't.
This is the advocate's challenge, to not lose the court's attention by being tedious, but not lose the client's wish by being incomplete. But on precedent, I propose to leave it. All I was going to say was,
I mean, what you can do on things like that is you give us the citation.
Exactly.
We'll look it up.
I know. Thank you very much indeed. And then on Appeal Ground 3, in addition, I shall move to consider the second aspect of the Morgan Grenfell dictum, which is the technical infringement point. Either one is the no infringement, two is the technical infringement, and explain that that is not good law either. And finally, under Appeal Ground 2, I'll come back to deal with the alternative if the Morgan Grenfell dictum is right. So I start with 1 and 3, and start therefore with the subheading of the key principles. My lords, my lady, I am acutely conscious that all members of this court will be very familiar with the cases and the principles on which we rely. Nothing could be more wearisome or irritating than being told in sonorous terms what you know already, and know very well, not least from the fact that only 10 weeks ago my Lord Justice Lewison handed down judgment in the Adelsey case, which itself in the first 22 paragraphs captures all the principles upon which we rely. So the short route might be to say we agree and couldn't wish to improve, and we do and we can't. But my lord and my lady, can I just say this, that knowing the principles, as this court does very well, and we recognise, is not necessarily the end of the matter. And we would, with your leave, and with, I hope, appropriate economy and deference to the enormous amount of accumulated knowledge of this area, like to invite your attention to aspects of the decisions in 6 cases which we submit engages the fundamental questions that arise in this case. And it is in our submission one of the features of where, with the greatest respect, the learned judge went wrong, was that what he never did was to take the essence of the underlying policy behind legal professional privilege, look at where it is justified in its hallowed state in our law, and then ask himself how the decisions that he made measure against or fit with that. And whilst we don't suggest for a moment that my lords, my lady, will fall into the same trap, of course not, we think it is helpful just to look at these 6 briefly, and I shall give you the principles you derive from them first in case you weary of my submission, so you have the principles first, but I'll identify the 6. The 6 are Darby justices, Morgan Grenfell, we have to look at that one in a little more detail for obvious reasons, B and Auckland, 3 Rivers number 6, Prudential and the Special Commission of Income Tax, and Adelsey and Denton's. And from those cases, we derive 6 principles which we hope are not controversial. And I shall just state them for brevity and then move on. And forgive me if some of this is a little obvious. LPP is a substantive fundamental human right. Secondly, the rationale which underpins the privilege is that the client must be sure at the time he and his lawyer communicate that what he tells his lawyer will never be revealed without his consent, which is a condition upon which the administration of justice as a whole rests. Thirdly, LPP does not involve a weighing up of the interest in keeping material private against other interests, such as in the interest of the court or a regulator having the full picture. Even, as you know, even in the most extreme case, where the client has no recognisable interest in asserting the privilege, and the interest in disclosure is compelling, privilege cannot be overridden.
No, I mean, yes. That's the, once you've got LPP, no balancing.
Yes,
That's
thank
a
you.
short point.
Fourthly, unless voluntarily waived, coming back to my Lord's point of earlier on, the protection provided by LPP is absolute, save for the 2 very limited exceptions, crime, fraud, and statutory override. Fifthly, privilege entitles the holder to keep the communication private in whatever context the issue arises, whether it is a civil case, a criminal case, or being outside legal proceedings altogether. And lastly, if a document or communication is privileged upon its creation, it is always privileged unless waived. Now, my lords, my lady, if that is a fair identification of 6 principles that underpin the rationale for and operation of the law of privilege in our modern law, it sets up a formidable edifice which has to be crossed or avoided in order for there to be any right in the analysis of the learned judge in this case, with the greatest of respect. But may I just take you, please, inviting being moved on, I stress, to the first of the 6 cases, and that is Darby, which is Bundle 1, tab 18. The facts were extreme, and in a sentence or two, whilst my lords find the authority may be worth my just saying, for your assistance. B, the ex parte B of the case, was arrested for the murder of a 16-year-old girl. He was arrested and admitted responsibility, but before his trial he retracted that statement and accused his stepfather of the murder. He was tried and he was acquitted. A number of years later, the stepfather was charged, and an attempt was made by counsel for the stepfather to cross-examine B as to the instructions he had originally given to his solicitor. He declined to answer on the grounds of privilege. A witness summons was then directed to B's solicitor seeking attendance notes and so forth, and then one to B himself. B sought to set aside the summons, and this ended up in the House of Lords, as you know, in 1995. It is maybe worth just noting this point in passing. Learned Friend says in his skeleton argument, and it's paragraph 27, I don't trouble you to turn to it, that the House of Lords discussion of LPP is obiter, in that they actually decided the appeal on a prior point. We think that's probably technically correct, but any merit in the point tends to fade when one considers how this has been treated, adopted, underlined, and developed since. But we just make that point in passing, in fairness to the criticism made by my learned friend. Famously, the leading judgment in Ex parte B, Darby Justices, was given by Lord Taylor, and I know that we have provided, of course, in accordance with the rules, the sideline passages, and I'm not going to dwell by reading out passages that support the very principles I've just enunciated. It seems to be a frightful waste of your time, and I see my lady agrees, so I'm grateful. What I will do, if I may, is just take you straight to page 507 in the top right corner. And underline, as well as sideline, the paragraph at D. The principle which runs through all these cases and the many more cases which were cited is that a man must be able to consult his lawyer in confidence, since otherwise he might hold back half the truth. The client must be sure that what he tells his lawyer in confidence will never be revealed without his consent. Legal professional privilege is thus much more than an ordinary rule of evidence, limited in its application to the facts of a particular case. It is a fundamental condition on which the administration of justice as a whole rests. And there is only so much I can get out of these well-known passages, and I don't intend to squeeze them for more than I can, but if one wanted an authoritative starting point for an analysis, we respectfully submit that's it. and we respectfully further submit that it remains good law, and therefore the no infringement reasoning under ground 1 and 3 in the Morgan Grenfell dictum is simply not consistent with it. If I could invite you please then to note on page 508 having referenced the arguments at the very top of the page of counsel who was acting as amicus, who was submitting the rule should not be absolute, but there may be occasions in which the rule should yield to some other consideration of greater importance. Lord Taylor goes on, just below letter B, to say this, but the drawback to that approach is that once any exception to the general rule is allowed, the client's confidence is necessarily lost. The solicitor, instead of being able to tell his client that anything which the client might say would never in any circumstances be revealed without his consent, would have to qualify his assurance. He would have to tell the client that his confidence might be broken if in some future case the court were to hold that he no longer had any recognisable interest in asserting his privilege. One can see at once that the purpose of the privilege would thereby be undermined.
And then at E, he says if there ever was a balancing exercise, it was done hundreds of years ago.
Exactly. Exactly. I needn't take my lords back to the 16th century, you'll be relieved to know. And so, in our submission, that from Lord Taylor's speech one can derive the obvious principles have been oft recited and stated, and I needn't delay them any longer, except perhaps to note this expression, because it just resonates, on page 266, between G and H, echoing what my Lord Master of the Rolls said earlier on. Once the privilege is established, the lawyer's mouth is shut forever. Take the language of a case from the end of the 18th century. At page 509, at H, sorry, that was in the speech of Lord Lloyd, I should have said. We have him making similar observations to those of Lord Taylor. And then we have the speech of Lord Nichols, who was dissenting to an extent. It sounds like a loose way of putting it, but I see my Lord Justice Lewison's reaction. I think you know what I mean. I mean,
He was doubting.
yes, yes. Well, if there is that such state, I would gladly accept the label. He was doubting, but
Because he agreed in the result, so he wasn't dissenting,
no,
but he wasn't sure about the lack of recognisable interest for him.
exactly. But he equates having an interest in asserting the right with the risk of prejudice, i.e., one has interest if there is a risk, and you see that from 510 between D and F, a passage I know that you are very familiar with. And although at 511E he deals with what he describes as a seductive proposition that is advanced, he, however, along with all the other members of the House, agree that that submission, seductive as it might seem, must be rejected. And at 512E he goes on to consider what happens when the client no longer has any interest in the privilege, and ties that back into the concept of prejudice. So we submit it is a powerful and important starting point when considering the modern law of privilege to take obiter or not, how it is put in Darby. Can I go to the second case, please, which is Bundle 2, tab 22. Morgan Grenfell. And you will remember the facts have been shortly stated. Morgan Grenfell devised and marketed a tax scheme. A special commissioner of taxes granted consent to an inspector of taxes for the issue of a notice under section 20, subsection 1 of the Taxes Management Act 1970, requiring the bank to disclose its instructions to and the advice of counsel in relation to the scheme. The decision was subject to a judicial review. The Divisional Court refused the application for judicial review and was upheld by the Court of Appeal. A different approach is taken in the House of Lords. This case is important for two reasons. It is important for its ratio, and it is obviously vital to the reasoning of the judge in this case for its dictum. Now, Lord Hoffman gave, as is very well known, the leading speech. And if I could invite you, please, to pick that up at paragraph 3, which you will see, forgive me, I've lost my reference to the page.
Page 606 of
Yes, thank you so much. Thank you. Yes, the House of Lords begins at 6:05, and as my lady rightly says, grateful to you, 6:06. You can see from how his lordship puts it in paragraph 3, the wording of section 20, subsection 1, which contains no exception for privileged material. And then if we can come on to paragraph 7 at the foot of that page. Two of the principles relevant to construction are not in dispute. First, LPP is a fundamental human right long established in the common law. It is a necessary corollary of the right of any person to obtain skilled advice about the law. Such advice cannot be effectively obtained unless the client is able to put all the facts before the advisor without fear that they may afterwards be disclosed and used to his prejudice. And then if one passes on to paragraph 16, and I could invite you just to remind yourselves of what is said there, please. It's right, perhaps, at this point to note that in the event the House of Lords unanimously decided that Section 21 of the Taxes Management Act could not be said to have excluded LPP by necessary implication. That is the ratio of the decision. And there is no debate about...
So the ratio of decision was that Section 21 had not overridden.
Correct. No statutory override, application fails. Had it stopped there, perhaps we wouldn't be here. But as we all know, there is more. It is indeed interesting to note, and perhaps I should just show you this, I know you've read it, but how Lord Hobhouse, in his speech, put, very neatly, if I may say so with respect, just how high the bar is for necessary implication. Can I show you paragraph 45, which is page 369 in the bottom right-hand corner? I just invite you to remind yourself, if you kindly would, of what he says there.
It's a very well known passage.
Yes. Again, very familiar ground. Could I invite you just to cast your eye, if you kindly would, between paragraph 25 on page 363 through to paragraph 29 on page 364, where he deals with the decision in Parry Jones. Thank you. And you will note, you know, and you've read this many times, I know, paragraph 30, where Lord Hoffman expresses his admiration for the strength of the Court of Appeal, but the difficulty he has with the reasoning. The upshot, putting it more brutally, lacking his courtesy and finesse, is that he says they came to the right result for the wrong reasons, a view that he also expresses later about Ex parte Taylor, second founding case upon which this principle appears to be based.
Are we going to look at Parry Jones at some point?
Yes, we are. It's one of 5 cases the learned judge relied upon, and I was going to take you to it. If you want to do it now, I can, but otherwise, yeah, certainly.
Because at the moment I can't see it's got anything to do with legal professional privilege at all.
Yes, well, may I say this, that when we get to it, I will be saying something like, it's got nothing to do with the modern law of legal professional privilege at all.
Mr Parry Jones was being asked for accounts,
Yes,
which are not privileged according to nationwide solicitors. This Justice Blackburn's decision, so that wasn't privileged anyway. And his ground of resistance was nothing to do with privilege, it was based purely on confidence,
yes, yes,
as was the injunction that he was after.
yes. And, well, yes, I agree. And I'll come back to whether it's of any use at all in due course. I mean, even if it once was, may I put it this way, it is stripped of its force with the greatest of respect as an authority by reason of having been, the ratio having been disapproved of in the House of Lords by Lord Hoffman. And so any force it once had is long since expired.
Lord Hoffman is relying on it to try and cast about for some explanation as to why Section 21 was included in the Taxes Management Act, appearing to protect privilege only to a limited extent as far as the documents were in the hands of the lawyers, with the Special Commissioner saying, well, that just shows that it's only protected to that extent,
Yes.
and not protected more broadly.
Yes. Then one comes to the heart of Lord Hoffman's reasoning on the dicta passage, paragraph 32. I merely invite my lords, my lady, to note the last sentence of 31 on the way past. It's nothing new, but it's just another reminder of the significance of the substantive right and its foundation in public policy. And then 32, this is not to say that on the facts the Parry-Jones case was wrongly decided, but I think that the true justification for the decision was not that Mr Parry-Jones' clients had no LPP, or that their LPP had been overridden by the Society's rules, but that the client's LPP was not being infringed. The Law Society were not entitled to use information disclosed by the solicitor for any purpose other than the investigation. Otherwise, the confidentiality of the clients had to be maintained. In my opinion, this limited disclosure did not breach the client's LPP, or, to the extent that it technically did, was authorised by the Law Society's statutory powers. It does not seem to me to fall within the same principle as a case in which disclosure is sought for a use which involves the information being made public or used against the person entitled to the privilege. And that is the high point of the analysis in this critical passage. And we respectfully make these submissions with appropriate deference, I hope, and always with courtesy, but they've got to be made nonetheless in our submission. Lord Hoffman is discussing here with himself that even if the reasoning was wrong in the Court of Appeal in Parry-Jones, the result was right. And that involved him reinterpreting the decision. And his reinterpretation has two elements to it. First, Lord Hoffman suggests the true reasoning is that the LPP of Mr Parry-Jones's clients was not being infringed because the Law Society could not use the information disclosed except for the purposes of their investigation, and this limited disclosure, as he would call it, did not breach the client's LPP. Alternatively, and if he was wrong in his first no infringement analysis, he says, if there was a technical breach of LPP, then it was authorised by the statutory powers. And the rationale for these two theories is expressed in the final sentence that we just looked at of 32, namely, that the situation, to repeat, does not fall within the same principle as a case in which disclosure is sought for a use which involves the information being made public or used against the person entitled to the privilege. So what Lord Hoffman does is this. He sees privilege as applying differently where the disclosure is not being used against the person entitled to it. And in this respect, he seems to have picked up the, I may borrow your word of earlier on, my lord, the doubting language of Lord Nichols alone in Darby, where he doubted whether LPP applied, whether the person whose privilege it had no interest in asserting it, or put a different way, it would not be prejudiced by its disclosure. We submit that there is no warrant for that view, in that what it does effectively is this: having recognised the substance of the right, as Lord Hoffman does, it introduces a workaround or a third exception, or call it what one will, founded upon the concept of use and prejudice. And we submit that it would be surprising if a judge as distinguished as Lord Hoffman meant by these half a dozen lines in an obiter passage in this judgment to so considerably change the protections ingrained in the embedded concept of legal professional privilege in the English legal system. We respectfully submit, putting it more plainly, you can't square the circle. That the principles do not permit of this exception at all.
Could you reanalyse it in terms of consent? When you instruct a solicitor, you know they are regulated by a professional body who is there to protect the interests of clients, and therefore implicitly you consent to that regulator doing its job.
Yes. Well, that has an interesting echo in this case. He could have done that, but whether it would have flown, if I can put it that way, I respectfully doubt. You will notice in the judgment in this case, there was what the learned judge called the waiver issue, where the FRC sought to argue something very similar to that, and it's a point upon which we won and there's no cross appeal. And so where it would take one, I'm not sure. But of course, my lord, and I don't wish to be discourteous at all, of course, my lord was quite right. Yes, he could have done that. He could have looked at it through the lens of consent. And obviously, if there had been effective consent on the facts of Parry Jones, or on the facts of this case, then the result may be otherwise, because obviously that is then, privilege falls away once one has the consent. But he didn't.
Insofar as he could also have just said in Parry Jones, the rules governing the power to call for documents to regulate solicitors must impliedly override the client's privilege, because otherwise they're never going to be able to investigate anybody. That would have been an orthodoxy that you can't quarrel with.
Correct. And my lady has preempted, most helpfully, the submission we'll be making later. I'd like to give a taster now, which is that this court should not regard our appeal as being, if successful on the infringement issue, as being some impediment to the Law Society properly regulating solicitors, because it just isn't, for the very reason that you gave. And it was section 46, subsection 6 previously, and it's got successor numbering in later iterations of the Solicitors Act. But my lady is, if I may say so, entirely right. Can I move on, please, to the third authority, which is in the same volume of authorities, and it is at tab 24, and it's B and Auckland. Again, very familiar, I know. As regards the facts, they're a little involved, and I'm not going to weary you with them unless it would be helpful to you for me to reprise them for you. But the one fact we'd invite the court to notice that in B and Auckland, in some cases, the privilege that the case was concerned was that of the firm, and in other cases, it was that of the clients. If I want support for that, it's in paragraph 12 of the judgment. But before even coming to that, could I invite the court to note, please, that the panel in B and Auckland included Lords Hope, Hobhouse and Scott, who sat in Morgan Grenfell. Now, Lord Millet, in fact, gave the speech for their Lordship's house. And if I could just invite you to paragraph 37 on page 411. From there on, Lord Millet collects a number of older cases and Derby magistrates and sums them up in what we would suggest these four principles, which are not in any sense surprising, but it's a synopsis. Once privileged, always privileged unless waived, no surprise. Privilege is the same for criminal or civil proceedings, prosecution or defence, no surprise. Refusal to waive cannot be questioned or investigated, no surprise. And the privilege is absolute, save where the communication is itself a means of carrying out a fraud, no surprise. And so this is another case that reaffirms...
Which paragraph are you referring to here?
I beg your pardon?
Which paragraph?
44, I think.
Yes. It's the passage that begins at 37 and leads through to 44. Thank you very much. And so here is a further restatement of what I would call the orthodoxy of the position of privilege in 2003 from the Privy Council.
Again, he goes on to say no balancing exercise.
Yes, thank you very much. He does, in 46. 54, on page 416.
As a matter of, if you step back towards a matter of principle, is there anything wrong? If you step back from it all, is there anything wrong with the proposition that if it be correct that a document is disclosed to a regulator, I'm confining it to these facts, by a regulator, and as a matter of law can be used for that and no other purpose, that that doesn't need to fall, shouldn't fall within the protection of LPP. What is wrong with that as a kind of just a general proposition? Your concern is it could be used elsewhere. I understand that point, but if Lord Hoffman's proceeding on the basis which he apparently was, that it can only be used for that purpose and no other, what is wrong with that? Why does that undermine the rationale for LPP, which you know about?
Well, in the scenario that my lord put to me, unless I missed it, you didn't deal with whether the document was itself privileged. So I'm assuming you mean the document is privileged and given over for that limited purpose.
The document would otherwise be privileged. It's the client's privilege. It would otherwise be privileged.
Right.
But we're talking about a regulator for solicitor or accountant.
Yes.
And the law was such that, irrespective of any statutory provision to that effect, the
Yes.
law was that it could only be used for that purpose and no other.
Yes. What would be wrong would be this, that it would immediately introduce an exception and an uncertainty which would infect as a possibility the stage at which the privilege crystallises. Was that the point as we were submitted of privilege itself is to allow a confidential space in which solicitor and client can communicate in confidence that it's never going to be revealed, subject to the two usual overrides, statutory and fraud. If one did, a principle that says, but one day I may be, as a solicitor, as your solicitor, investigated, or I may be, as your auditor, investigated by my regulator, the FRC, and this material may then be revealed, albeit only on my Lord's hypothesis and solely for the purpose of an investigation into the auditor, and not into you, the entity. It immediately undermines the founding principle of confidence that exists between client and solicitor. And it would be, if I may be forgiven the vulgarity, it would be the tail wagging the dog. It would be the tail of potential eventual use wagging the dog of privilege in the first place. Because you'd have a situation in which, in circumstances unconfined and undefined, an otherwise privileged document may come into the hand of a regulator. And if one had a situation in which the solely was set in stone, that may or may not provide a foundation upon which the solicitor and the client could work, but it is still, in our respectful submission, offensive to the notion that the privilege is absolute, other than statutory override, then everyone knows where they are, given to Parliament and so forth, marking its supremacy, or if you're running a fraud, and everyone knows where they are. And so in our submission, it would still constitute...
I understand that, but I'm just testing your case.
Yes, of course, of course.
But, you know, when a solicitor is dealing with a client, they don't normally say, well, you do understand that anything you give me may be disclosed in due course if I am under investigation, for example. I mean, that's not the way the world works.
No.
It's there, and that's just a part of the legal framework. You don't explain it to the client. So if there runs alongside a particular statutory exception, and this as an exception is a matter of law, if that were correct, why does it make any difference? You know, in the real world.
Well, in the real world of this regulator in this case, the client may say, well, then what does Schedule 2, paragraph 1.8 mean? I'm not running for the shelter of ground 2 just because it's easier for me, but in the end, it illustrates the point quite neatly in us.
They are, in some sense, they are related, are they not? LPP is a creature of the common law.
Yes.
And the common law was to start making exceptions in one case. There would then be a sort of thin end of the wedge argument about other cases. Regulators, on the other hand, are set up by statute or statutory instrument, and it's up to Parliament to decide what powers to give them, whether to allow them to override LPP or not. So there are two completely different systems in play here.
Yes.
And the integrity of the common law system is one thing, and parliamentary powers is another thing.
Yes. But whichever thing... Sorry.
I suppose if there was an investigation, if the client is dissatisfied with what the solicitor has done and makes a complaint, and the Law Society then exercises its powers to investigate the solicitor because of that or that and a number of other complaints, it's always open to the client, if he sees it in his interest, to waive the privilege, and then there's nothing the solicitor can do about it.
And that is a
They
point...
have to hand over the material.
Absolutely, and one of the authorities, and forgive me, I don't have the line to hand, Mr Sher will know it off by heart, but they make that very point. There's nothing the lawyer can do about it. If the client wants to waive privilege, that's tough on the lawyer, because it's the client's privilege, as you know.
But solicitors are sometimes the clients of other solicitors, and I can see that then, if one had an exception, on the basis that it's unlikely that the disclosure of the material to the regulator is going to be capable of being adverse in any way to the interests of the client, that may or may not always or sometimes be the case, but that's the client's call to make.
It is. And in that situation, where you have Solicitor A, who is a client of Solicitor B, Solicitor A is in no different to any other client. The privilege and the material would be his, and if he wishes to waive it, he waives it.
And if he wants to say, I'd rather not waive it because I don't want to be the next subject of their investigation, that's his entitlement as well.
Well, it is subject to the supervening power under statute of override of that privilege.
Yes, of that privilege.
The Law Society may not be chuffed about the concept that Solicitor A doesn't want to be the next target, so he hides material in the case for Solicitor B, or is entitled to. That's not how it works.
Well, one can't press the point too far.
No, but I understand the point. Thank you very much indeed.
So, just, and so I'm harking back a bit. Do you understand Lord Hoffman's statement to be creating a common law exception based on the proposition that where there is a duty to maintain confidence, such that a disclosure in that case for regulatory purposes could only be for that purpose, because otherwise there'd be a breach of this underlying duty of confidentiality.
Yes.
You understand him to be that's the proposition. Is that the proposition that you understand him to be making
Except
by
it's
way of
not.
a common law exception?
Yeah, I understand his proposition to be broader than just a regulator, because I don't think he doesn't limit it to a regulator as a matter of interest. It's only ever Lord Justice Arnold in this case who introduces the concept of it
No,
being.
the judges, I'm so sorry, Lord Hoffman says the Law Society were not entitled to use information disclosed by the solicitor for any purpose other than the investigation.
Yes.
Before that, he introduced this idea of the. Then he goes on. Otherwise, the confidentiality of the clients had to be maintained. So it has to be a relationship where there's a duty of confidentiality.
Yes.
And then he says, in my opinion, this limited disclosure does not breach the client's the LPP, or to the extent that it was. Then he goes on to the second point. Then he's contrasting that with a case in which disclosure is for a use which involves the information being public or used against the person entitled to the privilege. So it seems to be to do with an underlying duty of confidence which would otherwise be broken.
Yes.
I'm just trying to understand what your position is about this purpose exception.
Yes. This is a common law exception in the circumstances that Lord Hoffman identified to the rule.
But at the moment, it seems to me, if one were to deconstruct it,
Yes.
that what is critical here is that the reason why, leaving aside the statutory exception of technical breach, that the first part of it is there's a duty of confidence which will be breached if it were used for any other purpose than the investigation.
Yes.
That's as I understand it, although presumably that confidence rests not simply on the solicitor, but I suppose it must have to rely on the regulator too to be bound by it.
You certainly would. It becomes.
He doesn't go into that, but I mean, I suppose if he was to write this out fully, that duty of confidence would have to bind the regulator,
Yes, it would.
who presumably would know about it, because the danger would be that the regulator might hand it to somebody else.
Or the regulator may be under a duty to hand it to somebody else.
That's your parallel proceedings under the accountancy.
Exactly so.
But I'm just trying to understand
Yes.
what the principle is by deconstructing it. So, although he doesn't say this, it seems to me at the moment, but no doubt somebody else will comment, this might, it seems to me that it's a common law exception based on the principle that it can't be used for any other purpose than the regulatory purpose, because of a duty of confidence that binds not only the person who's giving up, i.e. the solicitor, the document, but everybody else, i.e. the regulator, into whose hands the document may come. That's as I kind of deconstructing at the moment. Does that sound... can you live with that?
I can live with that. But the exception, of course, as you know, and from the passage you yourself kindly just recited again at the end of paragraph 32, know that the exception has two aspects to it that on Lord Hoffman's thesis. The first is it's not to be used against the privilege holder. And the second is it'll stay confidential.
Yes.
Now, as soon as one of those is imperiled, then as its deconstructed maximum, the thesis, if I may say so with respect, collapses. Because if you can't guarantee it won't be used against the privilege holder, and you can't guarantee it'll stay confidential to that internal investigation of the third party, be it a solicitor or an auditor or whoever else it is, then on its best day it can't survive. Because it must therefore be a common law exception that is offensive in several respects, as well as being in principle at odds with the prior authority.
Yes. I mean, I think what you're saying, I think that what this comes to is that even in the scenario which he's postulating, which is this duty of confidence preventing a further dissemination of the material subject to legal professional privilege, that you're postulating that it can't be used by either the regulator or by a third party against the person entitled to the privilege.
Yes.
And I think you haven't said this, but my lady raised this just now. There may be a situation where, for one reason or another, they may be compelled to hand it over.
Yes.
One would have to investigate that. All I'm saying is, I think, maybe, but all I'm saying is, if the facts were such that none of those other possibilities arose, that's what he's talking about, that very narrow, I think he's talking about that very, very narrow area, which he seems to think in the Parry Jones case was satisfied. It couldn't be used against the client, it couldn't be used to be given to anybody else, either by the solicitor or by the regulator, by the Solicitor Regulation Authority or the Law Society. Then it didn't breach the LPP, but that is a new. That's nonetheless is a new departure from the absolute rule of common law. That's the short point.
Absolutely.
Even in though, I mean, I think the end of the point is, even in those circumstances, there is no authority before him for even that very limited exception.
Exactly.
What you're making. So effectively, he's making a new exception here, which didn't previously exist at common law.
Quite.
So you probably said all those things, but I'm just trying to work it out in my own mind.
It's more important that you say them than I say them. Much more important. But my Lord, you're entirely right. Entirely. And it's no doubt for this reason that in a couple of the authorities, you may have picked up along in your pre-reading, you'll be good enough to do, you get this expression, for example, on the Canadian cases, where they say, surely Lord Hoffman didn't intend to change the whole structure of the law of privilege in England in half a paragraph, in a dictum, in an otherwise regular judgment adhering to the orthodox principles. Exactly for the reasons that my Lord gave.
So I'm sorry, take that. Thank you.
No, not at all. We were in B and Auckland, and I was just about to ask you to remind yourself of the way in which Lord Millett puts the matter in paragraph 54 on page 416. And from B, the authority B, we draw three important conclusions. Firstly, as to context, B was decided on the basis of a reiteration of the fundamental principles of LPP, which were extensively set out. It's a case where the panel reconsidered, reminded themselves of the details. And if LPP in fact depended on whether the documents were going to be used against the person in question, if that was in fact correct, it is inconceivable that would not have been addressed, we submit. Morgan Grenfell, which I respectfully remind you, three of the panel in Auckland were on, was cited and considered extensively, not least because it was the pivotal decision on the meaning of necessary implication. And the decision is a brief one in Auckland. It is inconceivable that everyone simply overlooked what Lord Hoffman had said in Morgan Grenfell. Parry Jones itself indeed was cited to the court in argument. So the context for the decision strongly suggests in our respectful submission that from Morgan Grenfell, at least 3 of their lordships did not take away as a principle of privilege, of the law of privilege, that this extra common law carve-out for privilege that was identified by Lord Hoffman in paragraph 32 and 34 actually existed.
Is this what you're saying, that what they did in Auckland was an entirely straightforward construction of the legislation to see whether there was an implied override?
Yes.
And they did not go on to say, well, we'll start by saying we don't have to worry about that because this may or may not fit into the third exception created by
Yes, exactly so.
Lord Hoffman.
Exactly. And I said there were 3 conclusions. That's the second.
Right.
And the third is really just as important, and it's the opposite of what they said, tied to the one fact that I respectfully reminded the court of, i.e. that on the facts of Auckland, the privilege was shared in that some material was privileged in the solicitor's hands and some in the client's. Now, we submit, it is important to note, that one does not see in the examination of the case in Auckland any consideration of whether the documents are going to be used against the client or not. It just doesn't feature. And this is important, we respectfully submit, where the clients held the privilege and not the lawyer. Because if this case was, by reason of that analysis, on all fours with the situation of Harry Jones, as reinterpreted by Lord Hoffman and Morgan Grenfell, the result would have been different.
This was a regulatory context.
Yes, it was.
This was a law society investigating in its regulatory capacity
Yes.
a firm of solicitors and exercising powers under the Legal Practitioners Act.
Exactly the same as Harry Jones. Exactly. And we go so far as to say that if the dictum of Lord Hoffman and Morgan Grenfell were correct, and as I say, it can't have been forgotten about by the 3 of their lordships who are sitting in this panel, the result in B would have been different. Were the Morgan Grenfell analysis applied, the result would have been that the District Law Society was entitled to the documents which were the subject of the client's privilege. And a different result would have resulted where the documents were the firm's privilege. That would have been, in our submission, wrong, and in any event, whether right or wrong, was not the result in the case.
Which was the part which distinguished, or which said that the privilege was partly the lawyers and partly the clients?
It is paragraph 12, I think, from memory.
12?
May I just check? Sorry, maybe that's it.
So yes, in some cases the privilege
Yes.
is all that of the firm, in others the clients.
Yes. Thank you. Thank you. May I move to the penultimate authority that we're going to invite you to consider, which is 3 Rivers number 6. It's in the same volume of authorities, and it's tab 26. Now, the legal... I'm so sorry, it's tab 26 in volume 2. So 2 tabs on from where the Lordship was. Of course, the facts are very well known, and perhaps this synopsis will suffice in 3 lines, that the liquidators of BCCI sought an order for the disclosure and inspection of certain documents passing between the bank's inquiry unit and Freshfield to its solicitors as part of the Bingham inquiry into the collapse of the bank. The Court of Appeal held that legal advice privilege extended only to communications for the purpose of seeking or receiving advice in relation to legal rights and obligations, and did not extend to advice about how to present the bank's evidence to the inquiry. The House of Lords unanimously disagreed and reaffirmed the broad view taken of legal advice in Balabel, which we may return to in a different context later. But for present purposes, the significance of 3 Rivers 6 was the fact that in order to decide the issue at hand, their lordships found it necessary to consider and restate again the very rationale for LPP and the policy behind it. And we invite attention to the speech of Lord Scott, who was, of course, a member of the court in both Morgan, Grenfell and Auckland. And as he put it in paragraph 35, if I might invite my Lord's attention to that, it's on page 482. Legal advice privilege should, in my opinion, be given a scope that reflects the policy reasons that justify its presence in our law. Those policies are analysed, as you will recall very well. I'm not going to trouble you with the detail of them at this stage, in Lord Scott's speech. Starting at paragraph 23 on page 646 in the top right-hand corner, page 478 in the bottom bundle reference. But it draws on, if I may say so, with the greatest possible respect to Lord Scott, in paragraph 25, what it might be termed general themes that are strongly emergent by this stage in the law. And then one can come on, if convenient, to paragraph 30. Over to the top of page 481, if you kindly would. I know my lords have looked at this passage many times before, so I'm just highlighting a couple of points in passing. And then one comes to paragraph 34 on page 481, which we respectfully invite my lords to remind themselves of. My lords and my lady, forgive me, remind yourselves of.
No doubt draw attention to the fact that regulators are not an exception to the list of people against whose intrusion the client must be secure.
Exactly. Exactly. Just for your note, but not to trouble you with it at this stage, if it's of assistance to the court, Lord Roger, in his speech, says very much the same as that you have just been considering, and just for your note, it's paragraphs 54 to 56. So may I come now to the penultimate case, which I'd like to trouble you with at this stage, which is the Prudential case. It's bundle 3. And it's tab 33. As you will know, this 7-member panel of the Supreme Court were concerned with whether legal advice privilege extended or could be extended to encompass advice on taxation given by accountants rather than lawyers. The Supreme Court held 5-2 with Lords Clark and Sumption dissenting that legal advice privilege extended only to communications between the client and lawyer. For our purposes, which are narrow, obviously, the relevance of this authority is that it again involved the Supreme Court examining the nature and rationale of LPP, and in particular, legal advice privilege. And I'd like to just show you one passage and then invite you to side note for later reading two other passages, if I may. The passage I'd like to invite you to, please, first, is paragraph 17. It's on page 721. In the speech of the majority of Lord Newburgh. Where legal professional privilege attaches to a communication between a legal advisor and a client, the client is entitled to object to any third party seeing the communication for any purpose, unless 1, the client has agreed or waived its right, 2, a statute provides the privilege can be overridden, 3, the document concerned was prepared for in connection with a nefarious purpose, or 4, one of the few miscellaneous exceptions applies, e.g. in a probate case where the validity of a will is contested. We've considered 4, and we don't think it really illuminates the debate in this case at all. It's very specific and doesn't allow for some general let in our submission. And so we obviously, as my rather hackneyed reading betrayed, emphasise any third party and for any purpose. Nowhere does one find in this long decision of the Supreme Court anyone say that the client is entitled to object unless the document will not be used against him. Nor do we find anywhere it said the position is different if the third party is a regulator and it thinks it would be helpful if it could see them. Lord Newburgh's description of LPP is as orthodox as it is economical, and it is wholly supported by all the case law that we have looked at which precedes it. The two passages that I'd invite you just to note, if you kindly would, but don't want to trouble you with at this stage, is that whilst Lord Sumption was in the minority in the result, he analyses in his speech between paragraphs 111 and 121 the history of privilege to the point at which we've now reached. And in the second paragraph, the passage I'd invite you to side note would be in Lord Newburgh's speech between paragraphs 20 and 23. He adopts how Lord Sumption puts the matter and could not begin to improve on it, as Lord Newburgh says. And then at paragraph 21, 22 and 23 restates additional founding principles.
Presumably the reference in paragraph 20, penultimate line on the page to 11.
It must be
114.
Yes, I think. Sorry, I fell into the error of repeating the error. So forgive me, but yes, you're quite right. Thank you very much indeed. I'm sorry, there's 4 missing in the report. Thank you. And then, lastly, but in no sense,
does Lord Sumption in his analysis of the law up to now, does he refer at all to the Morgan Grenfell dictum? I see he refers to Morgan Grenfell and also to Parry Jones, but does he say anything helpful or otherwise about paragraph 32?
my recollection is the answer to my latest question is no, but I'm not going to finish, obviously, before 1 o'clock. May I check that and come back to you? I don't think he says anything of the sort. I don't. Just at the foot of page 744, in paragraph 119 at H, you will notice that he says it attaches to confidences given in circumstance where no proceedings were contemplated or where the proceedings contemplated were not litigation, but for example a domestic or public inquiry. And then third, in Morgan Grenfell, Lord Hoffman, with whom the rest of the House agreed, recognised at paragraph 7, etc., etc. So he deals with the authority, which I know is not my lady's question.
Well, it comes back to Morgan Grenfell on pages 748, 749.
Well, anyway, have a look.
Harry
Maybe.
Jones and 749.
Yes, he does. We'll have a look and come back with a better answer than I'm managing at the moment after the short adjournment. May I, subject to that point, come on now to the last of the authorities which we wish to cite as laying down the principles. May I just, first of all, just say something to Mr. Sherwood? Do you forgive me for 1 second? Sorry, thank you very much indeed. Thank you. It's same volume, tab 39, please. And it's my Lord Justice Lewison's judgment on Adelsey. My lords and my lady, it would be the height of forensic opportunism to simply stand here and say how wise and right a member of the court was on a recent previous occasion, and I shall not do that. All that I would do is to... sorry?
Since Roe lives.
I'll spare Mr Simpson's comments off. Is to underline, if I can put it in that way, between paragraphs 6 and 22 and then 26 of the judgment as being exactly right. And may I, without I hope being thought to be impertinent, highlight paragraph 29, where my Lord says in the middle of that paragraph at D, the client must be sure at the time when he consults his lawyer that without his consent there are no circumstances under which the privileged communications will be disclosed without his consent. And then my Lord cited the mouth is shut forever point that I took you to an hour or so ago. In paragraph 58, albeit in a slightly different context, my Lord says in the last sentence this,
So which paragraph?
58 on page 921, please. The recognition of exceptions would, in my judgment, undermine the policy of certainty that underpins legal advice privilege, which is a principle with which we most respectfully agree and which we most respectfully submit the judge's reasoning falls foul of. So may I please now turn to the next part of our submissions, which is that the judge's decision and his no infringement reasoning, drawing upon the Morgan Grenfell dictum, is inconsistent with a number of the core principles that the court has been good enough to revisit in the last part of our submissions, and if upheld would represent a fundamental shift in the law's attitude to privilege which should not happen. First, it is important to focus on the essence of the judge's decision. For this, may I invite you, please, to the core bundle. And this, my lords, my lady, you have the judgment separately. If it's in your bundle, it is tab 7. But you may have taken it out, I know. The key passage is paragraph 84 on our bundle numbering page 102. In my judgment, counsel for SDI is correct in his submission that Lord Hoffman's primary reason in Morgan Grenfell supporting the decision in Parry Jones was strictly obiter. Nevertheless, it was an important step in his reasoning in that case, and it has the persuasive force of the unanimous House of Lords. Moreover, it receives support from the subsequent case law. Notwithstanding the criticisms of it, there is no authority to the contrary. Accordingly, I consider that it must be taken to represent the current state of the law. Thus, the production of documents to a regulator by a regulated person solely for the purposes of a confidential investigation by the regulator into the conduct of the regulated person is not an infringement of any legal professional privilege of clients of the regulated person in respect of those documents. That being so, in my judgment, the same must be true of the production of documents to the regulator by a client. We respectfully submit that the principle which the judge is grounding his conclusions on with respect, not only does it represent in and of itself an extension of the pre-existing state of what he considers to be the law, by an extension from documents being produced by the professional to documents being produced by the client, hence the notice under paragraph 1.3 of Schedule 2 of SATCAR, but with the greatest possible respect to the judge, the principle, whether extended or not, is wholly inconsistent with the law of privilege and was at the time of the delivery of the judgment. And as to this, we make 4 points. First, the judge's reasoning introduces, as a matter of common law, not statute, special rules for how privilege applies where the documents are sought by a regulator that step is unprecedented and indeed doesn't spring directly from even the Morgan Grenfell dictum itself, which was instead apparently based on considerations of whether the client would be prejudiced. As we have seen, high authority establishes that privilege applies in the same way whatever the context. See, just for your note, for reference, Lord Taylor in Darby, page 503, between G and H, which reflects, unsurprisingly, that privilege status is a fundamental substantive right, and the fact that there is no balancing act to be done. So the fact that a regulator might rather like, for a perfectly noble and admirable purpose, to get its hands on some privileged material is, with the greatest of respect, irrelevant.
So are you really saying that the judge, so to speak, silently performed the balancing exercise?
Yes.
Concluded that the balance lay with the regulator?
He did. He did. He had to have done in order for 84 to make sense.
regulator who has a power to to compel the production of documents, generally, not looking at privileged documents, has to derive that power from some source. It might be statutory, I suppose it could be a contractual power conferred on it by people who want to be regulated by it and set up some code by which they all agree that they will give up their documents if asked to do so.
Yes.
But there will always be some underlying provisions conferring that power and governing the use of that power. So one might ask, well, why is this exception necessary? Because one can always construe the provisions which confer and govern the power to see what they say about privilege.
I quite agree, and without wishing to improve and thereby spoil my lady's point, which I accept, I'll probably make a hash of it, so forgive me. One has exactly that sort of situation in play here. Two reasons. One, if you look at the position of the orthodox law, express or by necessary implication. And so if one looks at the origin of a given regulator and asks the question, is it, if it's not express, by necessary implication to be deduced that they must have this power, for example, solicitors? How on earth are they to do their job as a regulator for solicitors if they don't have the power that they plainly do? The answer is there given. But the second point is that in this case, there is not only no such power of sufficient clarity to meet Lord Hobhouse's test of necessary implication in this analysis, which is common ground between the parties. I think that it's not pretended by the FRC that they have some power they're going to spring on everyone. They don't. But actually the power works the other way. And one of the oddities when we get there to the inward analysis of Schedule 2, and my lady is there long before I articulate this, is of course that you have here a provision which says in terms, unless privileged, shorthand, but it's to be construed as meaning the opposite. And so the interesting thing is, not only is my lady's primary point, which is the better one, very good, but if one then looks at the issue here, the obverse appears to apply. And the danger is of Lord Hoffman introducing, and it's back to the point that my Lord Justice Lewison asked me about right at the start in my second founding proposition, when I used the terms authorised by some statute or words to that effect. What is introduced here is some species of let or permission, in theory, sub the standard of statutory override of express or by necessary implication. Suggestion being something else less compelling will do. And that way lies trouble in our submission. It's not the law and it's not right. The second of the four criticisms we make of the learned judge's analysis is this. When one disregards the judge's interpretation of Lord Hoffman's observations as being limited to regulators, which it plainly isn't, it's a notion introduced by Lord Justice Arnold in this case. The proposition that is relied upon by the judge and the respondents in this appeal is an even broader inroad into the principles underpinning legal professional privilege, namely that, as the Morgan-Grenfell dictum suggests, privilege is somehow not infringed if the document is not being used against the person in question. which was Lord Hoffman's reasoning in Morgan Grenfell. But 3 points. One, such a view would represent a radical and unprecedented reformulation of the rationale and foundation for LPP. Two, although we have seen there are faint echoes of this in the language used by Lord Nichols in Darby, he alone expressed his doubts about privilege in those terms. And three, none of the authoritative restatements of the principles or its underpinnings, Darby, B and Auckland, Three Rivers, Prudential, Adelsey, support the idea, indeed they're inconsistent with it. Indeed, the view that infringement depends upon the privilege being used against the privilege holder, and therefore to his prejudice, is in our submission impossible to reconcile with numerous of the decided cases. It is interesting to look at this not just through the authorities in Adelsey, for example, or in Auckland, for example, but to look at it in one of the leading commentators in this area, Mr Charles Hollander, in his well-known authoritative book on privilege. Could I invite you just to have a glance, if you kindly would, at that now? It's Authorities Bundle 4. Tab 43. And you will have, I know, seen that the learned judge, in giving his judgment in this case, noted the trenchant criticism of the Morgan Grenfell case in some of the leading works on the area, although he doesn't then analyse it, but there we are. If I could invite you, please, on 1063, to the last paragraph on the page, having set out from the speech of Lord Hoffman and Morgan Grenfell the key point. Mr Hollander then says this is a difficult passage. Lord Hoffman suggests that the privilege protects the client from the document being used against him or from it being made public, but that the use of a document for the purpose of a law society investigation is not a purpose which is inconsistent with maintaining the privilege. However, to suggest that the effect of privilege is to protect the use of the document for purposes inconsistent with the policy of the privilege, but not for other purposes, is a radical view, which it is submitted as objectionable on a number of grounds. And then over the page he sets out 6, which I invite my lords, my lady, to consider in due course. For present purposes, for this submission, I invite you only to the point 6, which is in the first long paragraph. It's 3 lines up from the end. Sixthly, says Mr Hollander, a witness served with a summons to produce documents at a trial can claim his own privilege, even though it is not he is not the defendant and the document is not used against him. It's an interesting illustration of the problem with the approach taken in this case by the judge.
But if this principle were correct, and the disclosure to the regulator was not an infringement of the privilege, presumably that would mean that that disclosure was not a waiver of privilege otherwise subsisting in the document.
Correct.
So it's not saying that it's not a privileged document. It's saying that there's no infringement, but that would still mean that there would be an infringement if the document was disclosed in any other circumstance.
At best, that is, if this if this dictum is correct, which is the premise of my latest proposition, it could be addressed in this extremely reduced form. The revelation to anyone, any third party, for any purpose, a privileged document is an infringement. I do no more than borrow the language, if you will forgive me, of Lord Newburgh and adopt it and adapt it. And in our submission, it's as simple as that. The construct that one's left with otherwise becomes, and the reasoning becomes so inward and so convoluted, as has happened in this case when there is an attempt made to justify all this by my learned friends, that it doesn't really withstand any scrutiny. The third criticism that we make here under these criticisms of the judgment, and relatedly to the last, is that the no infringement reasoning in the Morgan Grenfell dictum is fundamentally inconsistent with the policy that runs through all the cases, that a client must be confident that what he says to his lawyer will never be revealed without his consent. The only true exception to that is statutory override, because, of course, we live in a country where Parliament is supreme and can make any law, even those inconsistent with fundamental rights, provided it does so sufficiently clearly. Back to the point about solicitors, for example, that my lady put to me earlier on. But if the learned judge in this case is right, or the Morgan Grenfell dictum is good law, then the client cannot have that confidence. If the appellant were to ask its lawyers, will what I tell you remain immune from disclosure in all cases? Under the law, as we submit it to be, the answer would be yes, unless Parliament expressly says otherwise. Full stop. Under the law as expressed by the judge, the answer would have to be, well, it all depends. If someone, perhaps a regulator, perhaps the revenue or the police, came along and wanted the documents to investigate someone else and promised you were not the target of that investigation, and they would do their best to keep it confidential, then you might be forced to reveal this, even if you never even provided the document in question to the target of the investigation.
Well, that in respect is expanding what the judge said further than the way he put it. Because if you go to paragraph 84, he's talking about the production of documents to a regulator by a regulated person for the purpose of investigating that regulated person.
Yes, but it's
not we might want to investigate somebody else.
No, but if I've overstated it, then please forgive me. But I didn't mean to, obviously. But it goes further, because in the last sentence of 84 it says, that being so, the same must be true of production by a client. So
Presumably for the investigation of that regulated person.
well, I presume so. Yes.
That must be.
Yes, must be.
All he's saying is that the regulated person can be required to provide the documents for investigation into himself, so can the client.
Yes. Yes. Well, I'm sorry if I overstated it then, in my flight of fancy. But
I do find this particular point a little bit difficult, because I mean, there's nothing difficult in saying to a client, indeed a solicitor may have to say that to a client if asked to, if put on the spot. Yes, it will never be disclosed to anybody except to a regulator in relation to a regulatory matter in which I'm being investigated. That would be, in fact, be correct for a solicitor, wouldn't it?
it would be correct for a solicitor to...
What's so difficult about that?
No, because it would be a matter of statutory effect, because the Solicitors Act has a statutory override.
No, I understand that. But, you know, you make it sound as though putting that proposition to a client is a matter of great difficulty or complexity or uncertainty, and there's nothing uncertain about that.
No, but the position that, as my lord put it to me, it is crystal clear and defined,
Yeah.
and this is not.
Well, if that was the law, and I'm saying if it was the law that it could only be used by the regulator and nobody else, and there was no doubt about the matter, and that nobody else could compel the regulator to hand it over, if that was the position, then there wouldn't be anything complicated about saying to the client that. The difficulty seems to me to come in relation to the ability of third parties to get that document from the regulator.
Yes.
And that's difficult to, it's difficult to know what that is in advance, because that could be another statute, or it could be another layer. But I'm not quite sure where this third point is getting to. It's fundamentally inconsistent with the policy that the disclosure without that there's disclosure without consent only in the exception of the statutory override. It depends what the law is.
Of course it does. Yes, of course it does.
Anyway.
Might I just ask one point? I've heard my learned friend, I'm not just making a forensic point here, but I've heard my learned friend say on a couple of occasions there is a statutory override in the Solicitors Act. I haven't heard that before. It's quite an important point, because if my friend makes that good, then it means that the decision in this case is a very narrow one related to the FRC. If he doesn't, then potentially it has very wide ramifications. And so, just for my purposes in my submissions, I'd be grateful if in due course that could be clarified. Because so far as I'm aware, there is no statutory override in the Solicitors Act.
Well, the issue doesn't directly arise in this appeal anyway, and I have said it, and I would say it again, because of the second limb to statutory override. I'm not saying I found some section that is express, but by necessary implication.
Necessary implication.
Yeah, exactly. I don't think I'm saying anything very surprising.
Well, I think there's no case on it, which I think the point that Mr Simpson is saying. I think, as I understood what you're saying, is that one could see, in relation to the solicitors, that I think it was Lord Millett who formulates a test, looking at the provision and adding the words "except for privileged documents." Is the regime then an unworkable regime as far as the regulator is concerned? And one might see that you're more likely to get to the answer, yes, it is an unworkable regime if it doesn't include any privileged documents so far as regulating solicitors are concerned.
Yes.
But insofar as this regime is concerned, it can work perfectly well without the disclosure of privileged documents, which may well be why Parliament said you don't need to disclose privileged documents.
Yes, exactly. That's all I can say. Thank you very much.
But what all these points come to, what all these points come to, I mean, simply this: if Lord Hoffman, if you're right about your criticisms of Lord Hoffman's dictum, then this suffers from exactly the same defects.
It is.
You're not sort of taking any further. You're simply saying, well, Lord Hoffman's analysis or dictum is wrong for all the reasons you've given us, and they're exactly the same reasons why the judge was wrong.
Yes. Yeah, that's all it comes to.
Yes.
Thank you for expressing much more economically the arguments. Subject, of course, to the judge's extension about the clients directly as opposed to,
Discuss that.
and also the judges limiting it to regulators. But apart from that, yes, I agree. And so the fourth point you make on this, before coming to the case law that was relied upon by the judge, which I shall come to as the next topic, is what was the answer from the judge in his judgment to these points that we have been making and we made below. Unfortunately, and with the greatest possible respect, there is no real answer. Because he says the law is what the law is, post dictum of Lord Hoffman in Morgan Grenfell, and I'm going to apply it in this terms, and that's it. So, although he notes the trenchant criticism, he doesn't, if I may say so with respect, grapple with it at all.
He doesn't really engage, you're saying, with the real nub of the difficulty.
Correct. He states the principles, but doesn't say how the principles work with his decision, and in our submission it is not a sufficiently robust analysis to withstand any scrutiny at all. Now, the same could be said of some of the submissions made in the skeleton of the learned friend, but I'm going to, with your leave, not get into the they say this and we say that argument at this stage. I'm going to leave it, deal with it in a reply if it's of assistance. Otherwise, I shall resist the temptation and turn the page. May I then come, please, to the authorities on which the learned judge relied, which is the case law which he says supports or leads to the conclusion that he reached. And also there was an interesting debate around precedent, which I'm going to, as I indicated much earlier on our submissions, leave for now. I've already noted in our submissions that apart from a very brief mention of the status of legal professional privilege as a fundamental right, paragraph 58, the learned judge doesn't engage, using the court's word, with any of the principles. Instead, he treated the matter as one which could simply be addressed by reference to what he called a line of cases concerning the regulation of lawyers and HMRC. I'm going to show you those cases quickly and explain why, in fact, they don't lead to the conclusion reached by the judge. But may I just summarise before we come to the detail of them, which I will, I promise, what they really amount to. Morgan Grenfell, obiter dicta, passage we've often looked at. Parry Jones, ratio disapproved, result upheld by Lord Hoffman. Taylor, ratio disapproved, result upheld by Lord Hoffman. McE, very different case, to do with statutory formulation of a test which would permit, a regulation that would permit the recording and eavesdropping on legal consultations between terrorist prisoners in Northern Ireland and their lawyers. So totally different to this, but helpful nonetheless. Sims, we respectfully submit no analysis at all of the issues now in play.
Is Lord Justice Waller's decision refusing permission to appeal a cited decision at all?
No, it's not, and that is as a result of a 2001 practice direction, which I think says that unless the decision granting or refusing permission says you can report this, you can't report it. It's not reportable. It's not citable. But in Sims, the court expressly said it was not concerned with whether Morgan Grenfell was right or wrong anyway. Lumsden, no analysis, and this case, and that's it. Now, my lords, my lady, I don't wish to be in any sense disrespectful, and I shall make good this proposition I'm about to advance, but this is not a promising start from which to fashion a new and third route in which privilege might be impregnated by the invasion of an outside agency against the client's wish, because there is nothing much in there. And I shall now take you to the cases, if I may. I promised I'd come back to Parry Jones, and I now do. Can I say this, though? It's bundle 1 of the authorities, tab 10. And whilst, of course, we can, we're all, my lords and my lady are very familiar with the detail of it, it doesn't repay, in our respectful submission, long study for the reason that I gave in debate earlier on, answer to my lord. Because it is common ground that the reasoning of the Court of Appeal does not represent modern English law, on privilege. And secondly, because it's a decision on confidentiality more than anything else.
Well, that was the only ground that Mr Parry Jones seems to have been relying on.
Yes.
If you look at the injunction he was after, which you can see on page 4,
Yes.
he's asking to restrain the defendants insofar as the notices purport to empower the defendants to have access to confidential information relating to any crime. That's all he's asking for. He don't seem to be certain of these things, and it may well be that since what the Law Society was primarily after was books of account, which as I understand it, aren't privileged. This is books of account. So says Mr Justice Blackburn in Nationwide
Yes.
and various solicitors.
Yes. So the reason we haven't looked at this before, but I promised I would, and why we don't need to dwell on it now, is for the better reason that my Lord gives, but also the reason that I gave, that even if privilege is in play, then there is no, the law then and the law now bear no relation to each other.
Well, are you saying then that at the time, so far as anyone knew, Lord Diplock was right to say that privilege was limited to disclosure within legal or quasi-legal
Yes.
proceedings?
Yes.
Right. So which was the case, was it Three Rivers that extended it beyond that, or had happened long before that?
Yes. I'm getting a lot of names behind me. I think it was actually, I'll check, but I see the time is 1 o'clock. But I think it's in legal advice privilege is extended. Not in Darby. Okay, in Darby, I'm told by Mr Sher.
Shall we stop now?
Certainly.
Come back to the case after lunch. So we'll start.
Thank you.
Full choice.